Me now is Laura Coates, CNN legal analyst and former federal prosecutor. Good morning, Laura.
Good morning, Carol.
Okay, so Martin explained it well, but I want you to explain it from a federal prosecutor's standpoint. There have already been competency hearings surrounding Roof, so why another one?
Well, every time you have a different phase of a trial, there is always the inkling by the judge to say whether or not the person should really, in fact, do what most people know is a kiss of death, no pun intended in this case. Representing yourself is a very difficult task for anybody, especially in a death penalty case, in a federal death penalty case, when you already have a conviction like this. So the judge is probably trying to take the temperature of the defendant once again. But remember, Dylann Roof was adamant about wanting to do this himself. He did not want to do the guilt phase. He wanted to do this phase. And the cryptic message of that judge doesn't really give us a whole lot of insight, but doesn't also change our perception that Dylann Roof may be using this as another springboard for his manifesto and to be able to convey the information that he wants to convey to the jury and the public.
I was just going to ask you about that because he wants to make this opening statement after prosecutors do in open court. And wouldn't that give him a prime opportunity to just recite his manifesto?
Of course it will. However, the judge, even if you are your own counsel, the judge does have reign still in that courtroom. And he could actually do something that people don't realize. He can have the counsel who's sitting standby of him actually retake his role if the defendant uses it as a circus or tries to hijack the proceedings for his manifesto. But we are all expecting some form of soapboxing here by Dylann Roof. This is somebody who planned these homicides. He planned and researched the different churches. He may not be in what we consider the right mind or the sound mind to have committed these horrible acts, but it doesn't mean he's not competent to actually defend himself.
Okay, so, well, he's not going to call any witnesses and he's going to present no evidence. So, is that part of the competency hearing, actually? I mean, will the judge try to determine what exactly Dylann Roof wants to do in court and base his decision on that?
He will, in part, look at the strategy of what Dylann Roof is trying to accomplish by being his own counsel. Remember, this is not a circus proceeding. The judge has a responsibility to preside over these proceedings and preside over the actual case. However, you are entitled not to call a witness. You are entitled not to do what people would normally think is the smart or prudent thing to do, but you are not entitled to soapbox and use this opportunity simply to cause further harm to the aggrieved parties, in this case, the 9 that were slaughtered by this man at the church. However, he does have a right to still speak his mind to a degree, as long as it's not disruptive to the proceedings and as long as he is towing the line of legal strategy. His only hope in this case, Carol, is to show the American people and that jury, in particular, of course, that he does not deserve death, that he does not deserve the death penalty. He deserves life in prison, and that is his goal, and he has a right to speak about it.
Okay, so a final question, because I talked with another attorney a couple of weeks ago who said if Dylann Roof does represent himself, that actually might help him because it would prove to jurors that he really is, not mentally all there, just by his actions in the courtroom.
That's the irony and the painful irony of all of this. But remember, just because he may be proving himself and he's in front of these people as potentially, and I use this term lightly, sympathetic to the jurors, you have to have unanimity when it comes to a federal death penalty. All he's hoping for is to sway one person on that jury to say, I had a visceral reaction to the way he committed these homicides, the way he terrorized these people, and I just can't bring myself to actually harm another person in this instance, or I cannot bring myself to choose death for this individual. So there may be hope for him in that respect to be able to sway or persuade somebody to feel even the small iota of empathy for his position, and it may inure to his benefit. But this is the case we're talking about. When we think about death penalty cases, you think about truly heinous crimes. This is it, Carol. This is it.
All right, Laura Coates, thanks for stopping by.
Thank you.
Still to come. You're welcome. Still to come in the newsroom.